I take your point that a holding that said that Congress could never pass a statute conditioning employees, making them follow RLUIPA, because that would exceed necessary and proper bounds, would be quite a holding. But the same would go for the coach, too. On the Title IX recipient, there'd be quite a holding for us to say Congress couldn't do that. I take that point, but I think it would apply to the coach as well. And I also think it's very different to say whether Congress could or couldn't do it. It didn't provide the clear statement it's required. And there's nothing novel about that. We just did that last year in Medina, for crying out loud, right?
Well, Your Honor.
At the government's urging.
Well,
right?
Your Honor, yes, I think that was right.
All right, and then, and then we'll go. If you want to finish, you want to add, feel free.
Oh, I was just going to say there's a really important difference between this case and Medina, which I've sort of mentioned a couple times, which is this case involves an express cause of action. So I think in Medina,
I understand that. The question is to whom, and whether there's clear notice. And simply saying it's not clear notice and there isn't consent, there's nothing novel about that. We did that in Dole. We've done that in Medina. We've done it not in Dole, but in a lot of other cases. We've done that, right?
I think that's right, but I do think there's clear notice here, Justice Gorsuch.
I understand you think that. No, on the clear notice point, you say, well, it was obvious even before Tanzen, right?
Yes, Your Honor.
What do we do about the federal government's representation in Tanzen itself that RLUIPA does not clearly authorize these suits against individual employees?
Yes, Your Honor, that's a fair question. So we were a party in Tanzen. We took a shot at the text, what we thought was a good interpretation of the text, and admittedly, we had an interest there in defending federal officers against damages suits. But hey, we lost, and we lost very badly. It was 8-0.
Well, that was RFRA, and absolutely you lost badly. But you said, with respect to state officials and RLUIPA, that it doesn't authorize. And now you're asking us to believe that it was clear, even though you got it wrong.
So, Justice Gorsuch, we've taken to heart this court's decision in Tanzen, and I think that Tanzen's analysis really does help the court decide the question. It doesn't govern squarely, but I think it does illustrate why the text means what it does here.